Have you ever been in that really frustrating spot where someone owes you money, maybe you've even got a judgment, but when you actually go to collect, it's like their assets have just vanished, like a financial magic trick?
Oh, absolutely. It happens all the time. It's incredibly common and deeply infuriating for creditors.
Leaves you feeling like, okay, I won, but now what? There's nothing left to get.
Exactly. You won the battle on paper, but the war for recovery feels lost.
So today we're going to take a crucial deep dive. We're digging into the really complex world of fraudulent conveyance recovery, and we're focusing specifically on how it works right here in Florida.
Yeah, our goal today is basically to pull back the curtain. We want to show you not just how these, financial disappearing acts happen, but crucially, how the law actually gives you tools to reverse them.
Our mission really is to demystify this whole area. We'll talk about the clever ways debtors sometimes hide assets, and more importantly, shine a light on the powerful legal tools that creditors can use to bring those hidden assets back within reach.
Think of it as a kind of masterclass in seeing through all the financial smoke and mirrors.
And to do that, we've been digging into some detailed legal analyses, focusing specifically on fraudulent conveyance, fraudulent transfers, trying to get a really comprehensive look at the strategies and the solutions.
Okay, so the core problem fundamentally is when a judgment debtor looks totally broke. On paper, they seem uncollectible.
Right, nothing there.
But in reality, they've often actively shifted assets, maybe to third parties, or they've found other, sometimes quite sophisticated ways to conceal them.
And this isn't just like passively hoping you won't find the money.
No, it's usually a deliberate act. The purpose, as our research really highlights, is specifically to defraud creditors, or at the very least, to significantly delay you collecting on that judgment. They're actively trying to make sure you can't get paid.
Okay, so if that's the problem, what's the solution look like legally?
Yeah.
Here in Florida, what tools do creditors actually have to fight this? Are there specific laws?
Oh, definitely. Florida law gives creditors some serious teeth here. There are two really powerful statutes that stand out. First, there's Florida Statute 59.26. It's often called the Proceedings Supplementary Statute.
Proceedings Supplementary, okay.
And what's really key about this one is that it allows a judgment creditor to, the legal term is implead.
Implead.
Yeah, it basically means you can add someone else as a defendant directly into your existing judgment collection case. Any person or entity that received assets as part of a plan to defraud or delay creditors can be brought right in.
Wow. Okay, so let's say someone owes you money and they sell their expensive boat to their brother for like $100 to take it away from me. Under this statute, I could potentially add the brother to my case against the original debtor.
That's exactly the kind of scenario it's designed for. And if the court agrees that the transfer was improper, fraudulent, or meant to delay, the court has really broad discretion.
What can it do?
It can order those assets returned to the debtor's estate. Then they can be subject to a sheriff's levy, where the sheriff seizes property or garnishment, like taking funds from a bank account, or other ways of enforcing the judgment.
Okay.
Or, and this is pretty powerful, the court can actually hold that third party, the brother in your example, directly liable for the debt, but only up to the value of whatever asset they improperly received.
That's a significant hammer. Yeah. But what about the person who got the asset? Did they get a chance to defend themselves? Like, what if the brother claims he had no idea what was going on?
Absolutely. While the statute gives the court a lot of flexibility to fashion a remedy, as they say, it absolutely ensures that the impleaded defendant, the brother, gets full due process. They have the right to present their side of the story, contest the claims, all of that.
Okay, that makes sense. So 59.26 is a big one. Is that the main tool, or are there others creditors should know about in Florida?
There's another major piece of the puzzle, and it often works alongside 59.26. It's Florida Statute 726, which is Florida's version of the Uniform Transfer Act, or FUTA.
FUTA? Okay. How's that different?
Well, FUTA also allows a creditor to void fraudulent transfers, but a key difference is that FUTA can apply both before and after you have a judgment against the debtor.
Oh, interesting. So you don't necessarily need the judgment finalized first. If you're a creditor with a valid claim, you could potentially use FUTA even before the court rules on the original debt.
That's right. If you have a claim, even if it's not yet reduced to a judgment, FUTA might provide avenues to challenge a transfer you believe was fraudulent. And it offers some different remedies too.
Like what? Beyond just undoing the transfer?
Yeah, beyond just voiding the transfer itself, FUTA allows for things like appointing a receiver. That's someone the court appoints to take control of the transferred assets manage them, maybe sell them to pay the debt.
Okay.
Or it allows for injunctive relief. That's a court order to stop something immediately, like freezing a bank account that received transferred funds or preventing the sale of a fraudulently transferred property.
So it seems like creditors have a choice, or maybe they can use both.
Exactly. It's not strictly an either-or situation. These two statutes, 59.26 and 726, along with their different remedies, can often be used together strategically, or sometimes one is a better fit than the other, depending on the specific facts like when the transfer happened, who received the assets, whether you have a judgment yet.
And I imagine timing matters too, like statutes of limitations.
Absolutely crucial. Each statute has its own statute of limitations, its own specific procedures, and slightly different requirements. So understanding those nuances is really key for any creditor or their attorney deciding how to proceed.
It really sounds like a comprehensive toolbox then. It's just about knowing which tool or maybe combination of tools is right for this specific situation you're facing.
That's a great way to put it. It's about matching the tool to the job of uncovering those hidden assets.
Okay, so we've got the legal framework down. We know the statutes.
Right.
And, knowing the rules is one thing. Figuring out what actually happened in the real world is another. How do these transfers typically play out? What are the common ways people try to hide things?
This is where the detective work really starts. Our sources point to some very common patterns. Probably the most frequent, you see this all the time, are transfers to family members, spouses, kids, siblings.
Classic move.
Very classic. But it also includes things like conveyances into irrevocable trusts, or shifting assets into business entities like LLCs or corporations, where on the surface, the debtor doesn't seem to have any ownership interest anymore.
So they make the ownership trail really complicated or just disappear.
Exactly, make it murky. And a key concept in uncovering these, something you often have to prove, relates to fair market value.
Ah, right. Tell us about that.
Well, a huge red flag and often a critical piece of evidence is showing that the person or entity who received the asset didn't pay fair market value for it.
So not just the extreme example like selling a mansion for $1.
No, it could be much subtler. Selling equipment to your cousin for half its worth, transferring property for love and affection instead of actual money, especially in these non-arm's length deals, as they're called, deals between people who aren't strangers, basically, particularly with relatives.
So that family discount could actually be evidence of a fraudulent transfer if the person giving the discount is trying to avoid creditors.
Precisely. That's exactly the kind of thing investigators look for. And uncovering it usually involves getting your hands dirty, legally speaking, subpoenaing bank records, financial statements, closing documents on property sales, emails, texts, anything that tells the real story behind the transfer.
You mentioned businesses earlier. What's a common way businesses might do this?
Oh, a classic one is a business racks up debt, then it abruptly closes its doors, seems like it's gone, but then almost immediately the same people, the principals, start up a new company. Sometimes it's even at the same location, using the same equipment, maybe even hiring the same employees.
But without formally buying the assets from the old company? Oh,
Right. They just sort of migrate the valuable parts of the old business to the new one, leaving the debts behind with the old, now empty shell company. It's effectively transferring the assets without paying for them, leaving the old creditors high and dry.
that's sneaky. What about moving assets completely out of reach, like offshore?
That happens too. Debtors sometimes transfer funds or title to assets to offshore jurisdictions, safe havens with strong bank secrecy laws, or that don't easily recognize U.S. judgments.
Sounds challenging to overcome.
It definitely can be. It adds layers of legal complexity, cost. You might need to hire lawyers in that foreign country, but it's not always impossible. If the amount of money involved makes it economically worthwhile, and depending heavily on the laws of that specific foreign place, recovery might still be possible.
But it sounds like in almost all these scenarios, the heavy lifting falls on the creditor, right? They have to be the ones to dig in and find this stuff.
Overwhelmingly, yes. The burden is typically on the creditor to conduct the investigation, to issue the subpoenas, gather the evidence, connect the dots, and then take the legal steps to prove the transfer was fraudulent and try to get the assets back or get a judgment against the recipient. It takes initiative and persistence.
Okay, the creditor takes the initiative, they gather the evidence. When they actually bring a fraudulent transfer claim in Florida, what exactly are the key elements they need to prove to the court?
Good question. Under Florida law, a transfer or an obligation the debtor takes on is considered fraudulent if one of two main things is true. First, if the debtor made the transfer or incurred the obligation with the actual intent to hinder, delay, or defraud any creditor.
Okay, so that's the straightforward, I'm trying to cheat you scenario. Clear intent. What's the other way?
The second path is what's called constructive fraud. This happens if the debtor made the transfer without receiving reasonably equivalent value in return.
The fair market value thing again.
Exactly. So they didn't get fair value back. And in addition to that lack of fair value, one more condition must be met. Either the debtor was already insolvent at the time of the transfer or became insolvent because of it.
Meaning they couldn't pay their debts.
Right. Or the debtor was engaged in or about to engage in a business or transaction for which their remaining assets were unreasonably small. Basically, they left themselves without enough capital.
Or the third possibility.
Or the debtor intended to incur, or reasonably should have believed they would incur, debts beyond their ability to pay as they became due. So they made the transfer knowing, or they should have known, it would leave them unable to meet their future obligations.
So it's either outright intent to defraud or this constructive fraud situation where they make a transfer for less than fair value and it harms their financial standing in one of those specific ways.
Precisely. And that covers a lot more ground than just intentional cheating. It actually has really old roots in the law. Our sources mention a famous Old English case.
Ah, yes, Twine's case.
That's the one. Way back, I think it was 1601, an English farmer owed money, so he secretly sold his sheep to this guy, Twine. But the farmer kept possession of the sheep, kept shearing them, marking them as his own. It was a sham transfer just to keep them away from creditors. The court saw right through it.
A classic example of trying to have your cake and eat it too, while leaving creditors with crumbs. So this basic idea has been around for centuries. How is it handled across the U.S. today generally?
Most states, including Florida, as we discussed with PECTA, have adopted versions of the Uniform Fraudulent Transfer Act, UFTA, or its more recent update, the Uniform Voidable Transactions Act, UVTA. Plus, the Federal Bankruptcy Code has its own very similar provisions for avoiding fraudulent transfers when someone files for bankruptcy.
And they all generally recognize these two main types of fraudulent transfers.
Yes, they all address both intentional fraudulent transfers, where there's that actual intent to hinder, delay, or defraud.
The Twine's case scenario.
Exactly. And then the really crucial one, the constructive fraudulent transfer.
And just to recap that, because it seems so important. Constructive fraud is where the debtor transfers assets, doesn't get reasonably equivalent value back, and the transfer leaves them insolvent or with too little capital, even if they didn't actually intend to cheat anyone.
That's the critical point. With constructive fraud, the debtor's state of mind, their intent, doesn't matter. It's purely about the economics of the transaction and its effect on the debtor's ability to pay their creditors. It can happen completely unintentionally, which leads to some really unexpected, sometimes tragic situations.
That constructive element really opens up a can of worms, doesn't it? It sounds like it could catch people completely by surprise, which I guess leads us into some of those unexpected traps and more complex scenarios our sources mentioned.
Absolutely. A really common and sad example involves what some call the sincere yet unsuspecting debtor. Picture this. Elderly parents decide to transfer the title of their home to their adult children.
Why would they do that?
Often, it's intended as a kind of do-it-yourself estate planning or maybe self-help probate avoidance. They think they're making things simpler for their kids down the road, maybe protecting the house from future long-term care costs, or just trying to be helpful, purely good intentions.
Okay. Seems harmless enough on the surface.
But here's the trap. Let's say sometime later, the parents run into financial trouble completely unrelated to that transfer, and they need to file for bankruptcy. Because they no longer technically own the home, they might lose the ability to claim their homestead exemption on it.
Which normally protects their primary residence in bankruptcy.
Exactly. So the bankruptcy trustee might be able to argue that the earlier transfer to the kids was a constructive fraudulent transfer, since the parents likely didn't receive reasonably equivalent value. The trustee could potentially void the transfer, take the house back into the bankruptcy estate, and sell it to pay off the parents' creditors.
Wow. So an act done out of love years earlier with no bad intent could cause them to lose their home in bankruptcy.
Precisely. A devastating outcome stemming from a lack of understanding of these rules. It highlights how crucial getting proper advice is before moving assets, even with the best intentions.
That's a sobering example. What about the people on the receiving end? Say someone buys an asset in good faith, pays something for it, but it turns out the seller was committing fraud. Are they just out of luck?
They have some protection, but it's limited. Under the bankruptcy code, for example, a good faith buyer who paid value without knowledge of the fraud can generally keep the asset only to the extent of the value they actually gave.
Creamy.
Meaning if they got a really good deal, say they bought a painting worth $100,000 for only $30,000, unaware the seller was defrauding creditors, they might only have a lien on the painting for the $30,000 they paid. The trustee could potentially recover the painting by paying them back their $30,000, leaving the buyer without the windfall they thought they had. They don't get the full benefit of the bargain if fraud was involved upstream.
So even innocence doesn't guarantee you keep the full asset if the price wasn't fair market value. Okay. Now, what about in the corporate world? Our sources mentioned leveraged buyouts, LBOs, as fertile ground for fraudulent transfer issues. How does that play out?
LBOs can get very complex, but the basic fraudulent transfer concern often arises like this. A company's existing owners or management want to cash out. They arrange for the company itself, or a new entity set up to acquire it, to borrow a large amount of money, using the company's own assets as collateral for the loan.
Okay, so the company takes on debt.
Right. Then a large portion of that borrowed money is used to buy out the old owners or managers' stock, often at a very generous price.
So the owners get paid from this new debt that the company now owes.
Exactly. The company is left saddled with significant debt. Its assets are now encumbered by the loan, and there might not be enough value or cash flow left to pay its pre-existing creditors, suppliers, bondholders, etc.
So the LBO itself effectively strips value out of the company for the benefit of the exiting owners, potentially leaving other creditors unable to collect.
That's the risk, and why LBOs are often scrutinized under fraudulent transfer laws. They can be challenged as either intentional fraud, if the purpose was clearly to stip creditors, or, more commonly, as constructive fraud, arguing the company didn't receive reasonably equivalent value for the obligations it took on, the new debt, and the payments made to shareholders, and that the transaction rendered the company insolvent or undercapitalized.
So a major red flag after an LBO is simply whether the company can still pay its bills.
That's often a key indicator. If the LBO pushes the company into insolvency or leaves it teetering on the edge, it's much more likely to be viewed as a potential fraudulent transfer.
And finally, one last point on complexity. You mentioned constructive fraud often depends on the debtor's financial condition at the time of the transfer. How do courts figure that out looking back sometimes years later? It sounds messy.
It historically was very messy. Determining solvency or adequate capitalization at a specific point in the past often involved expensive battles between opposing expert witnesses, accountants, valuation experts, each presenting their own analysis. It could be costly and, frankly, somewhat unreliable.
The dueling experts problem.
Exactly. However, our sources note a trend, particularly in U.S. courts handling complex cases like LBOs. There's an increasing focus on using more objective, market-based evidence and techniques to assess solvency and value rather than relying solely on subjective expert opinions, trying to make the determination a bit more grounded and predictable.
Okay, got a lot to digest. So wrapping this up, what does all this mean for you, our listener?
Whether you're running a business, you're someone who is owed money, or maybe you're just trying to navigate your own financial obligations, understanding the basics of fraudulent conveyance is actually incredibly valuable.
Yeah, it really underscores how important it is to be vigilant, doesn't it? And to act relatively quickly if you suspect someone who owes you money might be trying to make their assets disappear. The legal tools are there, but they work best when used proactively.
And it raises some interesting questions, too. In a world where financial dealings can be so complex, so opaque sometimes, and intentions can be hidden, think about this. How much should the law focus on the intent behind a transfer versus just the practical effect it has on creditors?
That's a deep one. And relatedly, as courts move towards these more market-based techniques to assess financial condition, what impact might that have? Will it lead to greater transparency, or will debtors just find new, more sophisticated ways to structure transactions to try and get around those objective measures? Something to mull over.